Hello and welcome back. Right, today we'll be looking at the sources of equality law, so where we get our laws from or where they are derived from. So we'll be looking at the provisions that we have at the international level, the regional level, and the national level. Right, so I'll share my screen now so that you can see my slides. Okay, right. So yeah, sources of equality law. Okay, so the right to equality and freedom from discrimination is protected under many international conventions and human rights systems. This right is founded on the principle of equality, which provides that all human beings are equal and therefore they are entitled to a set of rights, regardless of whatever their status is or the group that they belong to. So a number of human rights instruments provide for the framework, provide the framework for protection, of our human rights. All right, so we look at the first one, which I have here, which is the Universal Declaration of Human Rights of 1948. All right, so that's the UDHR. Okay, so this is the first international instrument that sets out the basic principles of human rights. And nearly every country in the world has ratified it. The UDHR, it was created after the Second War, and the atrocities, that happened during that war. So many countries from around the world, came together and founded the United Nations, to help maintain international peace and security. So UDHR is the foundation for the European Convention on Human Rights, okay, which has been incorporated into the UK through the Human Rights Act of 1998. There are two other international conventions known as the International Convention on Civil and Political Rights, the ICCPR, and the International Convention on Economic, Social, and Cultural Rights, ICESCR. So these two with the UDHR are together known as the International Bill of Human Rights. Right, so these human rights instruments, they provide for the right to non-discrimination on the grounds of race, sex, and religion. Okay, so and this, it binds all states. Okay, all countries are bound by this, whether they have ratified the convention or not, because it has been classed as a customary international law. Okay, and when it something has been classed as a customary international law, all states must abide by it as must do it as custom. Okay. Okay. Then the next one. Okay, so we'll look at these other two. Just briefly. So the International Convention on Civil and Political Rights, which this was adopted by the United Nations General Assembly in 1966, and it came into force in 1976. All right, so it recognizes the inherent dignity of the individual, all right, and seeks to promote conditions, within different countries, so that people can enjoy their civil and political rights. Everyone's rights are recognized and respected, okay, including men and women. Okay, so everyone is entitled to enjoy, civil and political rights. Nobody, irrespective of their gender, should be restricted from, political participation within their countries. Okay, the countries that have, ratified this convention, they are under an obligation to take steps, to protect the rights contained under this convention. And then they are also required to provide remedies, when these rights have been breached. Countries are allowed to derogate, from the provisions of the convention, under certain circumstances. For example, during a public emergency, so maybe there's a war that has broken out within a country, they are allowed to derogate, from the provisions of the convention. Okay. Okay, so then this convention has two optional protocols, and then optional protocols, they are like conventions, okay, which addresses certain issues that the main convention has failed to address. Right, so this ICCPR has two optional protocols. The first one allows the victims of a human rights violation to be heard, while the second one, aims to abolish the death penalty. Okay, then the second convention, the International Convention on Economic, Social, and Cultural Rights, which was again adopted by the United Nations in 1966, and it came into force in 1976. So this one recognizes the right of all peoples, to their self-determination. Okay, and it wants countries to commit towards granting economic, social, and cultural rights. Then it also recognizes the right to work. Okay, so it says people should have a right to work, right to fair conditions of work, social security, adequate standard of care, right to food, clothing, and housing. Okay, so that means if a country ratifies this, then they have to ensure that people have these rights. Okay, it obliges the states to provide at least a minimum level of these rights. Okay, but I mean, this can be difficult to achieve, because states don't have limited resources to ensure that this is provided for everyone. Okay, then the next one, all right, we have the International Convention on the Elimination of All Forms of Racial Discrimination. Okay, this so this one was adopted in 1965. Okay, again by the United Nations General Assembly. States that have ratified this convention try to condemn and eliminate racial discrimination. Okay, so it guarantees the right that everyone without a distinction as to race, color, or national or ethnic origins. Okay, so everybody should have a right, no matter what their race is, or what their color is, or their national or ethnic origin. It also asks states to commit to make it a criminal offense if people incite violence based on another person's race or ethnic origin. Okay, then another one we have the International Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. Okay, so CEDAW was adopted again by the United Nations General Assembly in 1979. Okay, and then it also has an optional protocol as well. Okay, so CEDAW is described as international bill of rights for women. Countries are, they're expected to take measures, or temporary measures or legislative measures to ensure that women are protected against discrimination, and that that they have the same rights and equality with men. Okay, the countries are supposed to provide equal opportunities and access to women, in areas of employment and political political and public life. Okay, the convention also guarantees reproductive rights of women. Okay, that women should have a right to their, they should have reproductive rights, and then it targets it asks countries to try to eliminate discrimination by focusing on tradition and cultures, that kind of shape gender roles. Okay, so these I think, yeah, these are the a few of the international conventions, that we get these laws from. Okay, and these ones, it talks about, every, like the UDHR, and the other two talks about everybody in general, while the one on the racial discrimination focuses on race, and then CEDAW focuses on women. Okay, so everyone, is entitled to um, to equality of rights. Okay, so we have special measures that the international instruments have recommended that states use to eliminate discrimination. If you remember last week, one of the lectures we did talk about special measures. Okay, so there are special measures in international instruments. They refer to a temporary legislative or administrative actions, that states are to adopt to remedy the disadvantage faced by a group, due to their past discrimination. Okay, it is based on the principle that laws and policies are not enough as a means to secure equality for the disadvantaged, groups. So just leaving it up to laws and policies is not enough. So it asks states to take extra steps, take extra measures, put some measures in place, to ensure that the disadvantaged groups, are able to enjoy their, full rights under the law and their fundamental freedoms. Okay, so special measures, they are also referred to as positive action, affirmative action, or affirmative measures. Okay, I mentioned in my last video, one of my videos, that positive action is the term that we use in the UK. Okay, however, let's not confuse this with positive discrimination. They are not the same thing. Positive action and positive discrimination is not the same thing, and positive discrimination is unlawful in the UK. Okay, so the special measures, they should be a proportionate means of achieving a legitimate aim. Okay, and it should be temporary. Okay, it should not be of a permanent nature. Okay, so it should be temporary, legitimate, and necessary, and it should respect the principles of fairness. So as soon as whatever objective that the government is trying to achieve, once they achieve that objective, then the measures should be discontinued. Okay, they're not supposed to be of a permanent nature. Then we have. Okay, so we have special measures, contained in CEDAW, and then the race one. Okay, so in CEDAW, it is contained in Articles 4.1, 4 sub 1, and then Article 4 sub 2. Okay, so this it requires states to use effective policies and programs to protect women, and to also abolish discriminatory laws. Okay, so he wants the government, to empower women, okay, and also provide an enabling environment for them. The one under Article 4 sub 2, that one deals with maternity, okay, and it says that it should, whatever measures that the government put in place for pregnant women, that it should not be considered discriminatory. So whatever it is, as long as it's directed towards pregnant women, it can never be discriminatory. Okay, but now, like I said to you, special measures should be discontinued once they achieve the objective. But for me, I think this the one for pregnant women would sort of be of a permanent nature, because women will continue to get pregnant. Okay, so yeah. Then the ICERD one, so that's the race one, also requires states to use special measures to remedy the disadvantages that people of a racial group has that has due to their past disadvantages. Okay, so this you can find it in Article 1 sub 4 and Article 2 sub 2. Okay, all right, so according to the UN General Recommendation on Special Measures, so these are some of the practices that they said, that states can use when they are trying to, achieve their objectives. Okay, so remember I said special measures have to be, they can be legislative action, executive or administrative one. Okay, so whatever it is that the state thinks is necessary to achieve a certain objective, to achieve equality between groups. Okay, so we have outreach or support programs. Okay, so I did talk about some of these when we looked at positive action. Okay, so you may want to refer to that. All right, but however, outreach and support program could be something like maybe the state can come up with programs that they can target at a certain group to help them eliminate disadvantage. So say for instance, I do know that girls do perform well in STEM subjects. However, you find out that there are not a lot of them compared to boys, university and in the employment area. Okay, so the government could come up with programs that are targeted at girls in secondary school, to help, kind of motivate them, to take it further into university and in employment. And then we have allocation and reallocation of resources. Okay, so that one, again, so if there are resources, they can, allocate it, to sort of, again, for using this STEM subject as an example, okay, they could allocate whatever resources they have to secondary schools, to help them, help girls go into such subjects. We have preferential treatment, okay, targeted recruitment. Again, I think I did mention something like that in my last lecture. Okay, so they could target people from an underrepresented group, encourage them to, to apply. Okay, so there are so many types of measures that governments can use. Okay, so under this maybe preferential treatment and numerical goals, an example I can give under that will be Norway and even quota systems. Norway and Spain, some of these Scandinavian countries, they do use quota systems in their they're trying to bring up the number of women on corporate boards. Okay, so they use quota systems that they use, kind of to get more women on corporate boards. So they could have something like, I think it's 40%. I'm not so sure right now, but I think it's 40% that they said they have a particular year that they want that to be achieved. That at this certain time, they want 40% of women on corporate boards. Okay, so and if they don't do that, then the government may penalize them. Okay, so these are ways that different governments can come up, with different ideas or strategies, to try to increase participation of underrepresented groups. All right, so I think, yeah, so that's it for at international level, the provisions that we have, that we get our laws to protect against discrimination. Okay, so I mentioned one for women and race. Okay, there are other ones. There's no way we can look at all of them, but I just sort of narrowed it down to the ones that are relevant to the characteristics that that we will study in this course. Oh, okay. Okay, so we go on to look at regional laws. Okay, so regional laws, they are, laws that apply within a region. Okay, so in our own case, that would be EU law. Okay, however, I will leave the future application of that to your EU lecturer to clarify, in the event of this Brexit. Okay, but right now we'll still look at that. All right, so the EU, the European Union has played an important role in developing the discrimination law, in the UK, especially in the field of gender equality, and more recently, in the field of age, religion, belief, and sexual orientation. Okay, the provision to eliminate inequality and promote equality between men and women, can be found in Articles 8 and 10, as well as Articles 2 and 3. Originally, EU law, was committed to the principle of equal pay, for the same work between men and women, but it later expanded to other areas, like conditions of employment and social security. Okay, so we have a number of directives that provide, for this. So I would like us to just briefly look at some of them. Okay, so we have the Equal Opportunities and Equal Treatment Directive. All right, so this ensures the implementation of the principle of equal opportunities and equal treatment between men and women in employment and occupation. Okay, so this directive defines direct and indirect discrimination. It defines harassment, instruction to discriminate, and then and treatment of women, less favorable treatment of women, in areas of pregnancy and maternity. Then the next one, the equal treatment, for the self-employed. Okay, so this provides for equal treatment between men and women who are engaged in self-employed capacity. All right, so it focuses on things like non-discrimination, on things like establishment, equipment, or extension of a business. Okay, so men and women should not be treated differently. Then we have the Gender Equality Directive, which extends protection against sex discrimination outside of the field of employment and vocational training. It also implements the equal treatment between men and women, in access to supply of goods and services. All right, so men and women should not be discriminated against, when goods and services are being, supplied to them. Then we have the framework directive for equal treatment in employment and occupation. Okay, so this establishes the general framework for equal treatment of men and women in occupation. So it applies in employment. Selection criteria, in recruitment, in promotion. Okay, so it applies in different areas. So men and women are to be treated equally, but there are some exceptions in the areas of disability, okay, and age, which can be justified. But in disability, it makes provisions for reasonable adjustments. Then we have the Race Directive, which implements the principle of equal treatment between persons, irrespective of their racial or ethnic origin. However, in this area, the EU has, taken fewer actions, in race discrimination in contrast to sex discrimination. Okay, then we have the national law. Okay, so you can see that here I haven't really written anywhere, not much there. Okay, so when we talk of the national laws, they are laws that are applicable within the country. Why I haven't written anything is because we'll be looking at them in more detail, in other lectures. Okay, however, the Equality Act of 2010, prohibits discrimination on 9 grounds, which we have already looked at. So that's the protected characteristics. And it makes 4 types of discrimination unlawful, which is direct discrimination, indirect discrimination, harassment, and victimization. Okay, so like I said, we'll discuss them further. Okay, so I'm not going to go into detail here. And then we also have some provisions of the Human Rights Act, which are relevant in this area. Okay, we'll look at those in another lecture. Right, so this brings us to the end of sources of law. So these are where equality laws have been derived from. Okay, so it started from the international community, and we have the human rights systems, the UDHR, okay, which was the first one. When after the war, after the Second War, a lot of the people's rights were badly breached. Okay, so they came up with these instruments saying that everyone is entitled to their rights, irrespective of their gender or their race, okay, or whatever characteristics they have. Okay, so now over time, these has now trickled down. The regional laws, were based on these laws, that the international the laws from the international level. So the regional laws are based on that, and then some of our national laws are also based on the regional laws. So you see how this sort of kind of trickles down. Okay. Yeah. So that brings us to the sources of our law, and yeah, and then I'll see you next week. Oh, next lecture.